Welcome to today's session from Utkal Success Academy. Today, we will study the judiciary. The Indian judiciary, covered under Articles 124 to 147, is the guardian of justice, operating as a unified system. Its main functions include interpreting laws, settling disputes, and protecting the Constitution. The court hierarchy consists of the Supreme Court, High Courts, and Subordinate Courts. This chart illustrates the hierarchy of Indian courts. At the apex is the Supreme Court, followed by the High Courts at the state level. Subordinate courts are divided into district courts for civil matters and sessions courts for criminal matters, with further categorization into lower courts. Key functions and powers of the judiciary include acting as the guardian of the Constitution by protecting fundamental rights through writ jurisdiction, exercising judicial review to nullify unconstitutional actions, and operating as an independent body separate from the executive and legislative branches to ensure impartial justice. Judicial appointments for the Supreme Court and High Courts follow the collegium system, governed by Articles 124 and 217. The process involves the collegium sending names to the central government, which must appoint if the collegium reiterates its recommendation. Lower court judges are recruited through state exams. Subordinate judiciary appointments involve the governor, in consultation with the High Court, for district judges, and exams for judicial service. The collegium system evolved through the three judges cases, shifting power from the executive to the judiciary. The NJAC reform attempt in 2014 was struck down for violating the independence of the judiciary. Judicial review is the power of the judiciary to examine the constitutionality of legislative and executive acts, covering central, state, and administrative actions. Its constitutional source is derived from Articles 13, 32, 226, and 246, enabling courts to strike down laws that violate fundamental rights. Landmark cases defined judicial review. Marbury v. Madison established the court's duty to interpret the law. Kesavananda Bharati established the basic structure doctrine, identifying judicial review as part of it. Minerva Mills v. Union of India reaffirmed judicial review as a basic feature, immune to constitutional amendments. Question 1. The doctrine of the basic structure was pronounced by the Supreme Court in the Kesavananda Bharati v. State of Kerala case, which is answer B. Question 2. Which was the first state to establish the institution of Lokayukta? The correct answer is B, Maharashtra. The Lokpal and Lokayuktas are anti-corruption bodies functioning as an ombudsman recommended by the first ARC in 1966. The Lokpal and Lokayukta form India's anti-corruption framework. Lokpal operates at the central level, investigating officials including the PM. Lokayukta operates at the state level. While they are investigative bodies, they cannot directly jail or fire for corruption, but offer recommendations, with crimes tried in special courts. A major difference between Lokpal and Lokayukta is the investigation of the Prime Minister. Lokpal requires a 2/3 majority of the bench for investigation. The inquiry must be held in camera, and if the case is dismissed, records cannot be published. Question 3. The collegium system was first introduced in relation to the judiciary. The collegium system appoints and transfers judges and was introduced through the three judges' cases judgments, not through a parliamentary act. Question 4. The Supreme Court of India is different from its U.S. counterpart in its advisory role, which is answer B. India's Supreme Court, under Article 143, can advise the president on legal questions, even without an active case. The U.S. Supreme Court only adjudicates real cases. The other options are incorrect because both courts act as the guardian of the Constitution and the supreme judicial authority, and both possess writ jurisdiction, though the scope differs. Question 5. The power of the Supreme Court of India to decide disputes between the center and states falls under its original jurisdiction, which is mentioned in Article 131. This power is exclusive, as no other court can decide such disputes. Original jurisdiction means a case starts directly in the Supreme Court. Article 131 handles disputes between the center and states. Exclusive jurisdiction means only the Supreme Court has the authority to hear federal disputes, such as center versus state or state versus state. A key comparison is that Article 131 jurisdiction is both original and exclusive. In contrast, Article 32, protecting fundamental rights, is original but not exclusive, as high courts can also protect these rights under Article 226. Advisory jurisdiction involves the president seeking the court's opinion, not contested disputes. Appellate jurisdiction reviews lower court decisions. Federal disputes start directly in the Supreme Court under its original jurisdiction, making other options incorrect for this specific scenario. Question 6. The power of judicial review implies that the Supreme Court can declare laws passed by the legislature and orders issued by the executive as unconstitutional if they contravene any provision of the Constitution. This is the correct definition of judicial review. Reviewing subordinate courts is part of supervisory jurisdiction, not judicial review. Reviewing its own judgments is the power of review under Article 137, distinct from checking other government branches. Initiating cases on its own is part of suo motu power, or judicial activism. Question 7 asks about the collegium system. Statements I and 4 are correct. The collegium handles appointments and transfers of judges, and the outgoing Chief Justice recommends their successor. The system is based on judicial precedent, not an act of Parliament, and the SC Collegium comprises the CJI and 4 senior-most judges. Statement I is correct. The collegium handles appointment and transfers. Statement 2 is incorrect. It's a judicial innovation, not a parliamentary act. Statement 3 is incorrect. The SC Collegium is the CJI plus 4 senior-most judges. Statement 4 is correct. The outgoing CJI recommends the senior-most judge as successor. Question 8. The first modern judicial court in India, presided over by Elijah Impey, was set up in Kolkata. This was the Supreme Court of Judicature, established at Fort William in 1774 under the Regulating Act of 1773. The first modern judicial court was established in Kolkata to replace the Mayor's Court and provide a formal judicial structure for British subjects in Bengal, Bihar, and Odisha. Sir Elijah Impey was its first Chief Justice. Question 9. The motto, Yato Dharmastato Jaya, meaning where there is righteousness, there is victory, has been adopted by the Supreme Court of India. It is inscribed on the Supreme Court's emblem below the Dharma Chakra. Question 10. Regarding the impeachment of a Supreme Court judge, the correct statements are A, B, and C. The removal is under Article 124(4) on grounds of incapacity and proven misbehavior, and requires a minimum of 100 Lok Sabha MPs to initiate the motion. Statement D is incorrect because the president cannot pardon a judge in a constitutional removal process. Article 72 applies only to criminal convictions, not removal for misbehavior or incapacity. The removal process requires a motion signed by 100 Lok Sabha or 50 Rajya Sabha members, followed by an investigation by a 3-member panel. The motion must then be passed by a special majority in both houses before the president issues the final removal order. Question 11. Article 141 of the Indian Constitution provides that the law declared by the Supreme Court shall be binding on all courts in India. This establishes the doctrine of precedent, ensuring uniformity in legal principles across the country. Article 141 makes Supreme Court rulings mandatory for all other courts, promoting legal certainty. Article 131 addresses original jurisdiction for center-state disputes. Article 144 mandates all civil and judicial authorities to aid the Supreme Court. Article 145 concerns the court's rulemaking power. This chart compares key provisions for the Supreme Court and High Courts. The Supreme Court's establishment is covered under Article 124, while the High Courts is under Article 214. They are courts of record under Articles 129 and 215, respectively, granting them contempt power. We can see further comparisons in the table. The power to issue writs is under Article 32 for the Supreme Court and Article 226 for High Courts. Appointments, oath, and salary of judges are also delineated, with separate articles for the two courts, primarily in the 120s for SC and 210/220s for HC. Let's explore the distinction between procedure established by law and due process of law under Article 21. Procedure established by law means life or freedom can be taken away only if a law exists and is strictly followed. This doctrine focuses narrowly on whether the legislative process was adhered to, without evaluating the law's fairness. It originates from the Japanese Constitution and protects mainly against arbitrary executive action. A harsh law passed by the legislature remains valid if the procedure is followed. Conversely, due process of law requires a three-part check: existence of a law, proper adherence to the law, and that the law itself is fair, just, and reasonable. This doctrine originates from the American Constitution. In India, the judiciary interpreted due process into Article 21. This provides protection against arbitrary actions by both the executive and the legislature. The Supreme Court effectively made procedure established by law equivalent to due process of law. Article 21 of the Indian Constitution guarantees that no person shall be deprived of life or personal liberty except according to procedure established by law. During the Constituent Assembly debates of 1948, the framers chose this phrase instead of due process of law to avoid excessive judicial interference in legislative matters. Initially, in the A.K. Gopalan case of 1950, the Supreme Court interpreted Article 21 narrowly. However, in the landmark Maneka Gandhi case of 1978, the court expanded its meaning and held that any procedure must be fair, just, and reasonable. As a result, Article 21 today is broadly interpreted and effectively incorporates the principle of due process in India. The Supreme Court of India has struck down several unjust laws to protect constitutional rights. Section 66A of the IT Act was removed for violating free speech. The electoral bond scheme was canceled to ensure transparency in political funding. Section 497 of the IPC was struck down for violating equality and dignity, while Section 303 was removed for imposing an unfair mandatory death penalty. These judgments show that laws must be fair, reasonable, and constitutional. Question 12 from 2022 asks about the correct statements regarding these two procedures. Statements 1 and 2 correctly define them. Statement 3 is incorrect as the origins are swapped. Therefore, option B, that 1 and 2 are correct, is the right answer. Question 13 from 2023 also tests this distinction. Statement I describes procedure established by law, and Statement 2 describes due process of law. Since the statements are swapped, both I and 2 are incorrect, making option D the correct answer. Emergency provisions under Articles 352 to 360 deal with extraordinary situations threatening the nation. They include national emergency, state emergency, and financial emergency. During such periods, the center gains greater control, the system becomes more unitary, and certain fundamental rights may be restricted to manage the crisis effectively. The Constitution provides 3 types of emergencies under Articles 352 to 360. National emergency is declared during war, external aggression, or armed rebellion, and greatly increases Union powers. State emergency is imposed when constitutional machinery fails in a state, placing the state under central control. Financial emergency may be declared when India's financial stability is threatened. These provisions help the government respond quickly during serious national crises. State emergency, also known as President's Rule, is imposed under Articles 356 and 365 when constitutional machinery fails in a state or when a state does not follow Union directions. It must be approved by Parliament and can continue for a limited period. Financial emergency, under Article 360, may be declared when India's financial stability is threatened, though it has never been imposed so far. These provisions allow central intervention during serious administrative or economic crises. During a national emergency, certain fundamental rights may be restricted under Articles 358 and 359. Article 358 automatically suspends the freedoms guaranteed under Article 19 during an external emergency. Article 359 allows the President to suspend the enforcement of certain fundamental rights in courts, except Articles 20 and 21. At the same time, the Union gains greater control over states, making the system more unitary for effective crisis management. Let's review some practice questions on the national emergency. For the first question, we need to identify the correct statements regarding the national emergency. Statement 1 is correct, as the President can declare an emergency based on war, external aggression, or armed rebellion. Statement 2 is correct. The center gains power to direct states. Statement 3 is also correct. The proclamation does not suspend the state legislature. Statement 4 is incorrect due to the maximum 6 months at a time constraint, which can be extended under certain conditions. Thus, 1, 2, and 3 only are correct. Moving to question 2. During a national emergency, our political structure transforms from federal to quasi-federal. Question 3 asks about the duration of the national emergency if approved by both houses. The answer is 6 months. In question 4, we evaluate two statements. Statement 1 is incorrect because state governments are not suspended. Statement 2 is correct. Parliament can make laws on the state list. The correct option is B, 2 only. Question 5 refers to Article 355, which is the Union's duty to protect every state against external aggression and internal disturbance. This duty reinforces the core value of unity and territorial integrity of India, making option B the correct answer. Thank you for watching this video. Utkal Success Academy is one way to success.